Hello and welcome to BYJU'S Exam Prep IAS. Before we start with our today's analysis, a quick gentle reminder. As part of our weekly current affairs explain session, today's discussion would be Shinzo Abe and India-Japan relations. Please do tune in live on our YouTube channel at 8 p.m. so that you understand everything about this topic. Let's get started and look into the first article. The first article says the great omission in the draft disability policy. The article here is speaking about the draft disability policy which was introduced by the Department of Empowerment of Persons with Disabilities. The article here is speaking about some of the concerns with respect to this draft policy, and we will also look at the greater picture about the disability issues. First up, we have to understand why did the government come up with such a draft notification. That is because when we go back to the year 2006, the government had released one of the policies with respect to the disabled community. However, when you look into the 2006 policy, it is not updated. What we are right now is in 2022. What we require is a constant updation of the national policies as well. In fact, when you consider the international level, India has also signed the United Nations Convention on the rights of the persons with disability. India has also come up with its own law as well with respect to rights of the persons with disabilities Act of 2016, and at the same time India is party to INCON strategy for Asian and Pacific decade of persons with disability 2013 to 2022, which is also called as INCON commitment. Since India is part of number of conventions at the international level, India has also come up with its own national law as well. The national policy has to get updated. The last time it was updated was in 2006, and now since we have to move with changing times, an introduction to a change has been introduced. When we speak about the INCON strategy, remember this happens to be the first set of regionally agreed disability inclusive developmental goals. There are people who are poor, there are people who are disabled in the Asia Pacific region, empowering them and also making sure that they achieve their goals is part of the INCON strategy. So to make it inclusive, to make sure that all these additional aspects after 2006 are taken into picture, the government has come up with such proposal. So the draft policy basically includes the principle to showcase the government's commitment to the inclusion and empowerment of persons with disability by providing a mechanism that ensures their full participation in the society. In furtherance of this commitment, the policy document highlights a detailed commitment to education, health, skill development, employment, sports and culture, social security, accessibility, and other institutional mechanisms. So, when we speak about the objective of the government, what exactly is the focus? The focus of the government in the present situation is to recognize all those people who have issues with the disability as a valuable human resource. Many people in India and elsewhere as well do not treat them with dignity because there is a social stigma as well. So, identifying such social stigma, ensuring that this is deleted from the society and making sure that these people are empowered is the objective of the government. And this policy also recognizes the persons with disabilities. They are entitled to their own set of rights and they should be treated equally with others. But what exactly happens? Because of the social stigma, they are not treated equally as well, and these people are ostracized in number of scenarios as well. So making sure an awareness is given to the people so that they are treated equally to other set of individuals is another objective. It also recognizes that there is a lot of discrimination when it comes to these set of people, so violating their basic rights, and unfortunately people do not change over a period of time. This also has been recognized under the draft policy, and it further recognizes the diversity of persons with disabilities. So making sure all this is rooted out, making sure that they are provided more opportunities and awareness is created and is given to the people so that ostracization and social stigma is rooted out is some of the initiative that will be undertaken as part of this draft national policy. As of now, the government of India has already taken number of measures. If we speak about the social empowerment, the government of India has come up with Accessible India campaign. It has also come up with unique disability identification project. When it comes to the physical empowerment, it has provided assistance to disabled persons for purchase, fitting of age assistive devices. When it comes to educational empowerment, it has provided scholarship for students with disability and also Deen Dayal Disabled Rehabilitation Scheme. And when it comes to the economic empowerment, it has also provided National Action Plan for skill training of persons with disability and concessional loan to the entrepreneurs. So what the government of India is able to look through this draft policy is that the focus has been shifted from individual to the society level, and at the same time it has also taken a larger picture of not only the medical issue, but it has also taken into picture other aspects of rights of these individuals. So they're not looking at these individuals only from the myopic viewpoint of the medical disability, but how are they going to be integrated into the social environment will also be taken as part of this policy. If we look into the statistics clearly go on to say that the 2011 census puts the number of persons with disabilities at 6.28 crores, implying 2.21% of the Indian population has some form of disability as compared to global average of 15%. As per census 2011, literacy rate of the total PW population is about 55%. In that, male is approximately 62%, female is about 45%. As regards higher education, only about 5% of the PWDs are graduate and above. Census data of 2011 further shows that about 36% of the total PWDs are employed. So this, when we consider the statistics, what we have to look at is that in seeing, there are people who have the difficulty, which is about 19%. In hearing, people have disability, which is about 19%. When it comes to the speech, there are people who have issues, that is about 7%. In movement, it is about 20%. Mental retardation 6%. Mental illness 3%. Any other 18%, and multiple disability is about 8%. And this is what the disability data is in India. Now, what is the constitutional principles and how are they safeguarded from the constitutional angle perspective? When we look into Article 41 of the Indian Constitution, what does it say? It says right to work, to education and to public assistance in certain cases. The state shall, within the limits of its economic capacity and development, make effective provision for securing the right to work, to education, to public assistance in cases of unemployment, old age, sickness, and disablement, and in other cases of undeserved want. So it makes a mention of disablement, and when we speak about these disabled individuals, it is mentioned in the 7th schedule, where in the state list, in the entry 9 of the list 2, which is about the state list. So it speaks about relief of the disabled and the unemployed. So it is mentioned in the 7th schedule. It is mentioned under Article 41 of the Indian Constitution, and the welfare of the PWDs also figure in the 11th and the 12th schedules of the Constitution pertaining to the Panchayat. But this article currently goes on to say, despite having all these positive measures, positive viewpoints, and an outcome that you're wanting to achieve, there are issues within this draft policy. What is the major concern? The major concern is we are speaking about empowering them on the educational level, providing them health and all these, which is good in itself. But the problem is they are not provided political awareness. They are not provided what is called as the political upliftment. So what do we understand by political upliftment? When we speak about these persons who are disabled, they have to be part of the political system. They should participate in the democratic principles. They should be able to contest the elections. They should be able to win the elections. And at the same time, in case we are speaking about democracy, it also takes into picture the right to vote as well. But these people have their major obstacles and impediments. They would not be able to go to the voting booth. They would not be able to cast their votes, and they also have major impediments which this article goes on to say that despite having thrown lot of information, having put in lot of resources to empower these individuals, they are not provided political upliftment, which is the very key for the disabled section. If you look into the article 29 of the Convention on the Rights of the Persons with Disability, it mandates that the state parties should ensure that persons with disabilities can effectively and fully participate in political and public life on an equal basis with others, directly or through freely chosen representatives. The Inkiong goals also promote participation in political processes and in the decision making. The Right of the Persons with Disabilities Act of 2016 embodies these principles within its fold. We have one of the sections called as Section 11. Section 11 under the Rights of the Persons with Disabilities Act speaks about accessibility in voting. So it says the Election Commission of India and the state election commissions shall ensure that all polling stations are accessible. But are these polling stations actually accessible? Are they able to go and cast their vote? No, says this article. In fact, there have been number of petitions that have also been filed in the past as well. Yes, Election Commission of India is able to take some steps, but it is not able to meet the intended objective. There is often lack of accessible polling booths in many of the locations. There is still no widespread adaptation of braille electronic voting machines as well, and even wheelchair services are not provided at the polling center. So this happens to be a major impediment. They are not provided political upliftment. So despite having all the advantages with respect to the draft policy, the major idea of political upliftment and empowerment is not taken into picture by this draft, says this article. The political parties in India still do not find the disabled as the large electorates to specifically address their needs. When we speak about the politics and the political parties, what do they have? They have the manifestos. And whenever they are elected to the power, they also come up with number of schemes and programs for the women as well, for the minorities, for the SC/ST community, for other section of people. Why? Because these are the vote banks for them. So they bring out their manifestos. They also come up with the freebies addressing a particular community, but when it comes to the disabled, it is not mentioned in the manifestos. When it comes to those people, the disabled community, they are also not coming out required policy as well as yojana. So this article goes on to say that there is lack of live aggregate data as to how many people are voting for the political parties, how many constituencies have number of disabled people, how are they going to the polling booth. This is not addressed by the political parties. The first visually disabled member of the parliament in independent India was Sadhan Gupta, hardly finds mention in our political or disability discourse. So what we have done is we have not given the political tool of empowerment to these sections of the society is the major concern under this article. Why is the representation important? That is because when we speak about the Constitution of India, the Constitution of India has provided reservation to the SC/ST community. Why is it provided? Because historically they were not provided justice. So to empower them, so to give them equal opportunities so that their political voice is also heard in the parliament as well as in the state assemblies, what they are provided is for the reservation. But when it comes to the disabled people, other people may not know what their concerns are. Other people may just speak about it, can actually go about sympathizing with their cause, but they do not know what they actually go through. So only when these people are empowered, only when they are given the reservation, they would be able to understand and come out with the policy initiatives for the disabled section. So the major reason being that as of now, there are no reservation for the disabled community. As a result, it is the disabled community which is suffering a lot, says this article. As a reformative move, one of the initiatives that has been taken which can be used as a model happens to be the Chhattisgarh model. What is this Chhattisgarh model? The Chhattisgarh cabinet approved an amendment to the State Panchayati Raj Act of 1993 which makes mandatory the presence of a person with disabilities in all panchayats across the state. Every panchayat will now have differently abled members either elected or nominated. So in case if the differently abled members are not not elected through the electoral process, then one member, it can be the male or the female, would be nominated as a punch. So we have the Chhattisgarh government which has initiated this move, and many state governments in the near future should also initiate such moves of providing reservation so that they are also politically uplifted, says this article. So, what is the way forward? The author in this particular case goes on to say that building the capacity of the disabled persons organizations and empowering their members through training in the electoral system, government structure, and basic organizational and advocacy skills have to be taken up. The creation, amendment, or removal of legal and regulatory frameworks by lawmakers and election bodies to encourage the political participation of the disabled has to be taken up. Inclusion of civil societies to conduct domestic election observation or voter education campaigns will have to be taken up. A framework for political parties to conduct a meaningful outreach to persons with disabilities when creating election campaign strategies and developing policy positions will also have to be taken up. So make them part of this process, make it inclusive in the right sense. So all the good ideas within the draft policy is good, but if you are speaking about the inclusive development, make them part of the process, empower them, make sure that these people are also part of the political process, is what is this article all about. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says how to grease the wheels of justice. The article here is speaking about the problem of pendency of cases in the Indian judicial system. We have a recent quote given by Justice C.G.I. Ramana. What does he say? Speaking at an event organized by Karnataka Bar Council, Chief Justice of India N.V. Ramana quoted former Chief Justice of US Supreme Court Warren Burger, the notion that ordinary people want black robe judges, well-dressed lawyers in fine courtrooms as sittings to resolve their disputes is incorrect. People with problems, like people with pains, want relief, and they want it as quickly and in an inexpensive manner. If we look into the statistics, the number of cases in India is as much as 4 crores and more. How do we divide it? If we look into the Supreme Court, there are as many as 70,000 cases for the year 2021. Do note, the data is up until September 4, 2021. In Supreme Court, as of now, we have about 70,000 cases. If we speak about the High Court, we have as many as 56 lakh cases across all high courts in India. And if we speak about the subordinate courts, its number goes up to 4 crores for the year 2021. How are they further categorized? If we have to speak about age-wise pendency of the cases, 0 to 1 year, it is about 32% in the subordinate courts. It is about 20% in the high court. 1 to 5 years, 45% in the subordinate courts, 39% in the high courts. 5 to 10 years, 15% in the subordinate courts, 20% in the high courts. And 10 to 30 years, 8% in the subordinate courts, 20% in the high courts, and more than 30 years, it is about 1% in the high court. So this basically means that there are large number of cases which are piling up in the subordinate as well as the high court. If you look into further data, 72% of the pending cases in high courts are the civil cases, 73% pending cases in the subordinate courts are the criminal cases, and this data is up until September 15, 2021. So this article currently goes on to say that because of the large number of cases that are piled up in the Indian judicial system, a legal maxim of justice delayed is justice denied is coming true, and it is the people who have become the major sufferers. So if India does not actively take measures, this percentage of pendency of cases will continue to grow as well. And if this continues to grow, people will start losing faith in the Indian judicial system. And if they start losing faith in the Indian judicial system, this may also lead to anarchy in the near future, as the last ray of hope for the people is the Indian judicial system. And if it fails, people will stop trusting the state, says this article. So this article currently goes on to say that it is because of the sluggish justice delivery system which has to be reformed. So it goes on to give two important parameters. So what are the measures that have to be taken? One, analysis shows that between 2006 and 2019, the average increase in pendency was less than 2% per year, whereas the average vacancy in sanctioned judicial positions was about 21%. If the sanctioned positions had been filled, pendency of cases would have gone down each year, says this article. So basically, as of now, there are judicial positions which are laying vacant. If we are able to fulfill, if we are able to fill in these vacancies, what we would be able to reduce is the pendency of cases. So this article says that when it comes to the subordinate judiciary, it is the role of the state governments and the High Court which has to fulfill all this and make sure that the vacancies are addressed. And at the same time, if we are speaking about the High Court as well as the Supreme Court, if it is to do with the High Court, the Chief Justice of the High Court and the Chief Justice of India, and if it is to do with the Supreme Court, the Chief Justice of India and the government, all these people will have to come together and make sure that the vacancies that are present in different high courts are fulfilled. So the first key recommendation is make sure that the vacancies that are existing in different high courts, subordinate courts and also in the Supreme Court is all addressed, is the first recommendation. The second recommendation is to make use of the technology. How is that we are going to make use of the technology? Computer algorithms should decide on case listing, case allocation and adjournments with only a 5% override given to the judges. What do we mean by case listing? Let's say, for example, you have a case that goes to the court of law. Which case will appear on that day? Who will be the parties in that case? How many cases will appear? And which case will come first? Which case will come second? Which case will come third? As of now is being done manually. So going forward, this entire case listing, which means which case has to be heard first, which has to be heard second, which has to be heard third on that particular day, this will require the computer algorithms. So the first come basis will have to be taken up and this discretion to the judges will have to be minimal. So judges' discretion should only be taken up in the exceptional situations where it is more to do with life and death. So if you're coming first, ensure that it is listed first, and adjournments should not be given every now and then, and case allocation or what is called as which judges should hear, everything should happen on a computer algorithm basis except for few expertise where it is required. Rest of it will be happening on the basis of a computer algorithm, says the first recommendation. The second is the court should also focus on e-filing. What do we mean by it? Let's say, for example, you have a civil dispute. A civil dispute is between one individual and another. So what should the advocates do? The advocates go to the court of law. There is something called as the filing section where they may have to pay the court fee, so on and so forth. So this article currently goes on to say that instead of they going physically to the court of law, filing all these via the papers, why not come up and make use of the technology? They would be able to pay online as well. They should be able to file all their cases online as well. This reduces the delay, this reduces and ensures that paper is also not wasted and everything is happening on the online process. Why not initiate it? So instead of they making their presence physically, come up with this particular idea where they would be able to make use of e-filing procedure. That's the second update with respect to the technology. The third is with respect to the virtual hearings. When COVID-19 hit, most of the High Court and also Supreme Court as well, they started hearing virtually. If virtual hearing continues and if the court is able to work in a hybrid model where if need be physical hearing will happen, and if it is not so important and for other cases it can also go via the virtual mode as well. So hybrid model embracing physical and virtual can be taken up by the courts in India. So the author also says if it is virtual, there will be many advocates who are from small towns, even they would be able to file their cases. They would also be able to argue as they would not be able to travel to the state capitals as well as to the national capital Delhi. So this article says that we have to embrace the technology. The third is in reference to Venkatachalaya report. The Venkatachalaya report, or what is called as the report of the National Commission to review the working of the Constitution, back in the year 2002 had come up with a recommendation. What was this recommendation? It said that the judges who are getting retired at 62 and 65, this should be further increased, says the Venkatachalaya committee report. If you look into Article 3 of the US Constitution, it says that the judges of the Supreme Court and subordinate courts hold their offices for the life. So they would be able to stay in the Supreme Court or in the subordinate court for their entire life until they are impeached. And at the same time, if you look into countries like Australia and Ireland, both have about 70 years, which is prescribed as the retired age. When you consider Canada, the upper limit is about 75 years. Why not introduce the same in the Indian system? When it comes to the judges, they take large number of years. They would be able to learn with experience as well. And by the time they have learned at the age of 65 years, they are asked to retire. So instead, we can follow what is called as any of these models is one of the recommendation of the Venkatachalaya report. Added to it, we can also look at alternative dispute resolution. The alternative dispute resolution, if taken on an online mode, is what is called as the online dispute resolution. So we can go with the arbitration, conciliation, mediation, so on and so forth. And ultimately, instead of these companies and individuals going to the judicial system, they can also explore other areas like lok adalats, negotiation in a well structured and in a channelized manner. So considering and exploring other areas like alternative dispute resolution can also be taken up. So some of the measures basically include: one is the vacancy, fulfill all the vacancies. Second is make use of the technology. Third, increase the retirement age of the judges. And fourth is explore other alternatives like the alternative dispute resolution. And if we are able to achieve all this, we would be able to reduce the pendency of the cases in the next few years, is what is this article all about. Now let's look into the next article. This article says, is protectionism compatible with the liberalization? So this article currently goes on to say that when it comes to India, we have been engaging in some of the protectionist measures. So this is not going to work out for India, and we have to bring changes to this protectionism model, says this article. So what is the principle of protectionism? Protectionism basically means that you have the government policies which restrict the international trade. What do? They impose tariffs. They also have international quotas. They also make sure that there are standards that are established so that international trade does not happen on a full-fledged mode. This basically means in order to protect the domestic industries, you put an embargo on the international trade to ensure that domestic economy is boosted, which is what is called as protectionism. So when it comes to protectionism, there are different kinds of tools that can be employed by the government. The first happens to be tariffs. What do we mean by tariffs? Tariffs are nothing but the taxes. So what will the government do? Let's say, for example, the government of India wants to regulate the automobile industry. So what will the government do? As of now, we have number of Indian car manufacturers. Let's say we have Tata, we also have Mahindra, so on and so forth. So what the government feels is that India has to develop, Indian cars have to develop. So only Indian cars has to be in the market. So for example, if the government says that it is imposing tariffs, that there are no imports that are coming from the foreign countries, let's say Hyundai, or let's say for example Tesla or any other company, where it imposes a maximum tariff of 50%, 60%, 30%, so on and so forth, that is what is called as tariff. So in order to give boost to the domestic cars, if the government imposes taxes, so that these cars, even if they are imported, because of the tariff barriers, even if they are imported, the cost will be exorbitant. So this is what is called as tariff, where taxes will be imposed on the import. Then what we have is the import quotas. What do we mean by import quotas? These are nothing but the non-tariff barriers. What exactly happens? Let's say for example, for United States of America, they'll be given a quota that we will be importing so many products from your country, but rest of the other products will be imported from some other country. So the number of products or the number of items that are received from a particular country, a quota is imposed. If that quota is breached, that country would not be able to export to India. That is what is called as import quota. Then what we have is the product standards. What do we mean by it? Let's say for example, there is a particular product. This particular product should have such and such criteria. It should meet such and such quality. If such quality is not in line as given by the government of India, that product will be completely removed. So the product standards can also be imposed by the government of India. Finally, what we have is the government subsidies. So if the government is giving subsidies to the homegrown industries, that means the product's cost will be comparatively cheaper if the consumer is buying that particular product. So if another product is coming from some other country, it will not be cheaper, and as a result, what will happen? People will go for this product which is comparatively cheaper. The government has subsidized this product, but if you juxtapose another product which is imported from some other country, it will be comparatively more because the Indian product is subsidized, that product is not, and as a result, most of the people will go for the Indian product. So basically, protectionism is nothing but government policy that restrict international trade, basically to help the domestic industries. Now the question is, why protectionism? That is because, as we just discussed, there might be domestic industries which were not able to compete with the international market. They would not be able to compete with the product that is coming from some other country. To give a boost to the homegrown domestic product, what the government comes up with is called as the protectionism. So protectionism basically benefits the domestic economy. So what are the arguments that are put forward for the protectionism? To give boost to the domestic industries, to also make sure that domestic industries also explore, they are also able to export. What we have is protectionism policies taken by the government of India. But this article currently goes on to say that such policies, if it is initiated by the government of India, will not serve us in the long run, says this article. What are the arguments given by the author? The author in this particular case goes on to say that if we are speaking about import substitution, what do we mean by import substitution? We are not allowing other countries' products to come to India. So this is not going to help us. Why? Because if we are import substituting with the local products, we are not giving the consumers the choice to buy their product. Irrespective of what it is the consumer who has to decide whether that particular product is good or not, and if it is not efficient, that product will be taken out by the market, by the people themselves. So if the government is coming up with import substitution, then the efficiencies will not match, and this will not meet the consumer's choice, is the first one. When we go back to the year 1970s, the government came up with Santa Cruz Electronic Export Processing Zone in Bombay. This policy basically focused at removing the custom duty for all the electronic products. Yes, the government did come up with this particular move in the year 1970, but this industry did not survive. It did not help this particular sector, but what helped was for the software industry and the diamond processing industry. The government came up with one of the policies for the export sector to do with the electronic industry, but India achieved success in the software industry as well as the diamond processing industry. So the market will decide what is good for the country, which consumer, which product has to be bought by the consumer. Even if the government does, it may in certain cases may not work. So allow the market forces to work on it, and you coming up with supporting one of the industry at the cost of the other will not help, says this article. Third, if we consider China or other Southeast Asian countries, they have been attracting the foreign investment. India has been requesting for the foreign direct investment, but it is not getting much of the foreign direct investment. That is because we are not able to understand what the market wants. If the market requires something, make sure that is supplied in the market. What China and what Southeast Asian countries have been able to do is they are able to plug the loopholes in the system. They are able to reduce the red tape, and at the same time they were able to discover what is not there in the market. But India unfortunately has not been able to plug this loophole. Ideally, we should have understood what we are good at, what are the issues in the market. If that particular industry is not explored, that should have been given the impetus, but that was not discovered, and as a result, China and other Southeast Asian countries have been able to get the foreign investments. India has not been able to, says the article. Fourth, government has to play the important role of the facilitator. Even if the government is not able to identify, speak to the industrial bodies. The industrial bodies know what is right for the country, and they are also in the competitive mode as well. They will also be able to understand where is the deficiency, which sector needs to be pumped in with more money. So we have to take the industries into the policy making, and their recommendations should be taken. So the government should not do things, but instead should be the facilitator to accommodate all those things that are required by the industrial bodies. So the industrial bodies, if they say that license raj is a major problem, the government will have to work on that. If they say permit raj is the problem, the government will have to work on that. If there are major impediments to the ease of doing business, the government will have to work on that. So take the industrial bodies into the consensus, and in case they are asking you for something, make sure that you become the facilitator, says this article. So going forward, what we have to do is not engage in protectionism, but instead the market will take care of itself. If quality is required, the domestic companies will have to sort it out, decrease the inefficiencies, and ultimately have to compete with the global products. Only when they are able to compete with the global products, we would also be able to export our product to other countries, says this article. So this article concludes that protectionism is not right for India, because on one side the customer will lose out on the choices, on the other side the market will not be allowed to take out or delete some of the inferior quality products, and ultimately it is the customer who suffers, says this article. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says the road to rolling out labor codes. The article here is speaking about the code on wages, which was passed in Parliament in August 2019, the industrial relations code, code on social security, and the code on occupational safety, health and working conditions, which have been passed in the Lok Sabha and Rajya Sabha, but these laws are yet not implemented. So this article currently goes on to say, why is that these laws are not implemented? That is because there are multiple reasons for it. The four labor codes are an amalgamation of 29 central laws and about 100 state laws that are similar to various central laws. Drafting, publishing and holding consultation with stakeholders is taking a considerable time. So when we speak about these laws, there were gigantic laws, many laws. These laws were all gelled up, amalgamated, joined together, and as a result the implementation is not that easy. The second says, the government says the delay in implementation is due to the delay in framing rules by the states. When you consider the labor, it is in the concurrent subject. So as much as the central government wants to implement it, it also depends on the states as well. So when it comes to the rules, these rules have to be made by the central government. They also have to be made by the state governments as well. But many states are not coming up with their own rules. As a result, there is delay in the implementation on one side. Because the laws are gigantic in nature, we join them together, implementation is taking time, but states also have to come up with their rules for implementation, but these states are not coming up with their rules. That is because some states allege that the code is actually poorly drafted, and at the same time the states and the center will also have to prepare rules in consensus, which is not happening. The states are publishing draft rules and inviting comments from the stakeholders on all the draft rules. Since the state governments have to come up with rules, they have been asking for the multi-stakeholder approach as well. They have to seek the opinion of the industrial bodies. They have to seek the opinion of the employers who are employing the employees, and they've also taken the employees also into the picture. Since all these people are involved, they're taking the feedback from these people as well, which is why there is a delay when it comes to this particular process. So this article says, apart from the delay in the implementation, there have been concerns with respect to these labor codes. What are the concerns? One, when it comes to the passing of this labor code bills, what happened? There was not much of discussion and deliberation in the parliament. These bills were passed as soon as possible. So many of the opposition political parties say that this was not discussed and deliberated properly in the parliament. That's the first major concern. When you look into the central trade unions, there are a number of trade unions. They also voice out concern that this particular particular legislation that has been drafted by the government of India is anti-worker. Why? Because it promotes hire and fire workers. There are no safeguards for the workers. It makes it harder for all the workers to negotiate with the employers, and at the same time, the very minimal security that was provided in the previous instances in the previous law is also being deleted in the present laws. So they go on to say it is promoting contractualization in the workforce, and since these laws are promoting the contractualization, it should not be implemented, says the trade unions. Added to it, the farm organizations have also supported the trade unions in their protests as well, and since there are mixed feelings to these labor codes, the government of India is also little reluctant and it is not implementing is another set of arguments. What is the way forward? Whenever the government is coming up with its own rules for the implementation of this labor code, it has to take into picture the viewpoints of the employee as well. Only after taking the viewpoints of the employee and the trade unions, this should be implemented. So the center, which is worried about the political fallout of its implementation, could possibly be the reason for the delay, says this article. It is this that we have to understand with respect to this article. Now let's look into the mains practice questions. Unless there is a political inclusion of the disabled, the goal of inclusiveness and empowerment will remain elusive. In the light of the statement, examine the draft disability policy. Next question, discuss the tools that are used to implement the policy of protectionism and critically analyze if this policy will hinder India's economic growth. Please write all your answers on the comment section, peer review, and do give positive feedback to your friends' answers. So this is it for today. Thank you for watching. All the best.